Okay, so we're now moving into the next slide. Sorry, it's item number 6 on your agenda there. It's equality for all customers of the Department of Social Protection, transgender recognition. I'd like to welcome the Transgender Equality Network Ireland, or TENI, to our meeting today to discuss with us their experience of equality of treatment at the Department of Social Protection.
I've been asked to address you on the legal aspects of the introduction of gender recognition legislation, and I'd like to reiterate at the outset that Ireland is obliged to do something to recognise the preferred gender identity of trans people as a result of the High Court decision in Foy versus An Cláraitheoir No. 2 from 2007. And it was the recommendation of the Gender Recognition Advisory Group that legislation will be the most effective mechanism by which to achieve this recognition. And I'm conscious that I have limited time to talk, so I'm going to keep my critique quite brief, and I'm willing to answer questions on anything afterwards. The GRAG in their report outlined 6 qualification criteria which must be met in order for an application for gender recognition to be successful. These are, firstly, residency or Irish birth registration, a minimum age of 18 years, people in an existing marriage or civil partnership will be excluded from the scheme. There must be evidence of clear and settled intention to live permanently in the recognised gender. You must live for a minimum of 2 years full-time in role before you'd be recognised. And finally, you must have a formal diagnosis of gender identity disorder plus relevant supporting medical evidence, or have undergone gender reassignment surgery with medical evidence thereof, or be recognised in an alternative jurisdiction. And I'm only going to critique 3 of these criteria at this time. The first one I want to talk about is the minimum age criterion. And it is an oddity, seeing as how it's legal to consent to to undergoing treatment for gender identity disorder at 16 years of age without parental consent, and of course you're always able to do it underneath the age of 16 with the consent of your parents. So to oblige people who undergo a transition early in life, particularly in the case of intersex children who may have been assigned a gender at birth which does not reflect either their identity or subsequent bodily development, to live with incorrect identification document until the age of 18 years is particularly injurious when we live in a society where the vast majority of schools are single sex, and this was recognised by the High Court in S versus An Cláraitheoir from 2009. The more problematic aspects of the scheme are the 2 that have been kind of touched on by my colleagues: the marriage issue and the medical issue. To require couples to divorce where one party has transitioned subsequent to the marriage in order for that person to be legally recognised in their preferred gender identity is, we argue, constitutionally unsound. The Constitution in Article 41.3.1 protects the institution of marriage. For divorce to be possible, according to our Constitution, a couple must live apart for 4 or 5 years with no reasonable prospect of reconciliation. This is not the case where a marriage survives one spouse transitioning gender. So for the trans spouse to be recognised, they would have to split up their family, perjure themselves in court in order to obtain a divorce, so that the trans spouse can be eligible to make an application under the proposed legislative scheme. This is particularly invasive to the rights of the non-trans spouse and any children of the marriage to remain members of a marital family. We suggest as an alternative that the legislation make no mention of marriage or divorce. And we recognise that this could create an apparent anomaly where post-recognition there would be what appears to be a same-sex marriage. However, we argue that this is not actually the case. In law, the crucial time when the validity of a marriage is assessed is the moment at which the marriage was entered into. We see this time and time again in the case of nullity, where the practice is to look at the situation of the individuals at the time the marriage was contracted. So by analogy, if a person is 78 when it's discovered that they were underage when they got married, that does not retrospectively validate their marriage. Similarly, we argue that because in the case of trans marriages, both parties presented and were legally recognised as being of the opposite gender at the moment of marriage, that they contracted what is a valid opposite-sex heterosexual marriage, which continues to be legally valid. The second issue I'd like to address is the medical evidence that the GRAG report would require. To recap, this is either a diagnosis of gender identity disorder or evidence of having undergone gender recognition surgery. Previous examples of this diagnostic criterion can be seen in the Gender Recognition Act of 2004 from the UK. When this was introduced, it was enormously welcomed because it dispensed with the need for an applicant to go any form of treatment prior to recognition, which represented best international practice at that time. Now, 8 years later, it has become the subject of criticism. As the legislation is confined to the specific diagnosis of gender identity disorder, it excludes a whole number of people who might need the rights contained in the legislation. For example, intersex individuals, those who are born with bodies combining both male and female biological characteristics. Additionally, the medical diagnosis itself is currently under review, and only yesterday it was announced that the wording would change and gender identity disorder would no longer exist as a medical condition but be replaced by gender dysphoria, which immediately invalidates the English legislation. And so it seems to us short-sighted to knowingly import an archaic diagnosis into Irish law. Additionally, the requirement to have undergone gender recognition surgery is a throwback to exceedingly outmoded understanding of gender identity, which the UK Act was lauded for abandoning. It's impossible to access treatment without the diagnosis, and so the requirement for interventions is worryingly retrograde. Increasingly, international human rights discourse recognises the need to depathologise legal gender recognition, to acknowledge that legal rights should not be contingent on medical treatment pathways. The current foremost example of international best practice in the area is the legislation introduced in Argentina last May, which simply enables an individual seeking recognition to complete a form outlining their preferred gender identity without any subsequent evidence or information. Thus, the person becomes the final arbitrator of their legal gender. The simplicity of the Argentinian scheme neatly avoids all the potential pitfalls of the GRAG's proposed scheme, and it is to this model which we at TENI suggest this Oireachtas looks in seeking a precedent for how to approach this matter. Thank you.
The position is at the moment is that they sought opinion, legal opinion, and they got that, and they had discussions with the Department's legal advisor on how best to proceed, and the Department is currently waiting on the legal opinion from the Office of Attorney General, who's in the process considering the various approaches suggested about the bill. So that's where it's at the moment. That's the most up-to-date information. But just in terms of my own questions, one was the Argentina bill. Was that passed into law in Argentina? Okay, because someone mentioned bill and just wasn't sure there. And the other one is maybe Tanya might let us know, would it need a constitutional amendment, do you think, to bring in legislation of this type you're suggesting? So just those questions. And if you could come back on the various questions, and also make your concluding remarks as well, because the budget is starting very early today. We will probably conclude then. All right. Okay.
I'll go first and answer the few specific legal questions, and then Broden can answer the more general ones and sum up for us if that's agreeable to everyone. So to start at the end and work backwards, to answer your last question first, Madam Chairperson, yes, the Argentinian bill was passed into a law in May this year. It was passed by the Argentinian Senate. In terms of why we looked to Argentina, Deputy Bannon, it's because it's the most rights progressive legislation worldwide, and it has been heralded internationally, globally, as the best legislative framework that currently exists on this issue. So it's better than anything that exists in Europe at the moment. So it represents best international practice. In terms of whether there would need to be a constitutional amendment in order to introduce this legislation, no, because the Constitution does not define what it considers to be a man or what it considers to be a woman, so it would have no implications on the Constitution in that way. In terms of whether the question has been put to the Constitutional Convention, it has not, so it's not something that's been considered. However, if it's something that were to be considered, the potential exists perhaps under their consideration of marriage equality to consider it as a secondary issue there because of the marital implications of the scheme as currently proposed by the Gender Recognition Advisory Group. But it's not there explicitly as an issue to be considered. Yeah, and there are all the legal questions that you guys asked. Thank you.